let's get on the record here in this case. This is CR 2014-1975 and CR 2015-14-16, State versus Stephen Casaus. Counsel, can I have your appearances this morning?
Good morning, Your Honor. Nicholas Marshall and Wesley Jensen for the state.
Good morning, Your Honor. Cindy Leos and Tom Clark on behalf of Steve Casaus, who appears in court today.
Good morning. So I think we're ready to get started. There were some preliminary issues that we needed to address before we brought the jury up.
I believe there are.
Yeah, come on up to the podium. Yeah, come on up to the podium. No, not here. To the podium.
Oh, I got you.
Can you come up to the podium?
I'm sorry,
Have something
Mr.
to-
Clark is going to argue this.
Okay.
Good morning, Your Honor. So the objection we received last night, redacted copy or redacted proposed redacted exhibit regarding Mr. Casaus' statement. And the state proposes to play Mr. Casaus' statement, I believe, in its entirety, except for certain portions that they want out. And our argument is, this is being offered by the state as a piece of evidence against Mr. Casaus,
sure.
And if they're offering said piece of evidence against Mr. Casaus, consistent with rulings you've made in the past, they don't get to pick and choose the good and the bad. Specifically, there are three sections regarding statements that Steve has made regarding loving his children and being a good father. Now, you've already ruled about some parameters that doors that we can't open, and we're prepared to live with that. But this is not our exhibit. This is the state's offering a piece of evidence they believe implicates our client in serious crimes, and the rule of completeness would require that it comes in. It doesn't open any doors. The state can't open their own door to bring in other things later. At the same time, this is not a piece of evidence that we're offering on our case in chief, nor is it something that we propose to admit portions of. This is Steve's statement to the police. And it's our position that based on your previous rulings, the state should either play the whole thing or not at all. And then, of course, if we're offering it in our case in chief, I think we would be required to live by your ruling about opening doors. But I don't think the state gets to use your ruling about opening doors, or us opening doors, to prohibit the jury from seeing things that Steve said during the course of his interview by the police.
Let me hear what the intent of the state is in terms of.
And Your Honor, there's two different things. There are two different discs that we're talking about from the evidence. One is the lapel camera from one of the officers when they were arriving at the house. And that contains different information that was discussed between the officers, just communications between the officers. So it's not communications that were with the defendant or the co-defendant. That part we edited just certain portions of the lapel camera that dealt with the officer's initial interactions with the deceased and with the defendant. We think those are admissible, and we would be offering those up for admission by the court. I think what we have here is, and then the other disc is portions of the defendant's formal interview at the police station, and we have cut certain portions out.
What portions?
Certain portions that we think that aren't relevant to the case. And what I think defense is trying to do is mischaracterize what the state is doing, because currently there's nothing in evidence. So what the defense is truly asking you to do is make the state admit evidence that they would like to have. They're trying to backdoor some character evidence and some other evidence that the state thinks is not relevant into admission without having to do it themselves. And it's in the rule of completeness isn't that you get to play the whole video. You only get to play the other relevant portions that are related to that segment of the conversation. And so that they're using the rule of completeness to try to include character evidence that has been excluded in our motions and from the motions in limine, and force the state to include it, and then not use the impeachment evidence that we could be able to use.